Welcome to the NFT Lawyer YouTube channel. Today we're going to be talking about something that's pretty near and dear to my heart. It's a topic that you've heard me talk about before, and it has to do with the two contracts that are part of every NFT transaction. Now, today we're going to have some pretty bad news for anyone that is an NFT seller or an NFT buyer. And this really difficult news to share with you is that, are you ready? If you bought an NFT from an open marketplace such as OpenSea or Rarible, your NFT under contract law is probably worthless. That is to say, you probably could not go to court and enforce any rights related to the linked digital asset to your token contract. Today we're going to find out why, so let's dig in. Before we start today, I want to tell you that this is not legal advice. Although I am an NFT lawyer, every situation is different. So if you have a legal issue concerning an NFT purchase, a sale, if you're a NFT project owner or you're running an NFT platform or you have any other legal issue concerning blockchain, make sure you consult your attorney. Let them know your specific situation, and that's the only time you're going to get legal advice. Today's video is not legal advice. All right, with that, let's dive right in. I have done a number of videos and written a number of articles, which are linked in the description below, about the issue of the token contract and the linked digital asset contract. There is also a great video by a YouTuber called The Legal Eagle. His real name is Devin Stone. He runs arguably the most popular legal YouTube channel covering all sorts of legal issues. That video is also linked below. I highly recommend that you take a look at it. Now, you're going to find that Devin Stone does an analysis of NFTs. There's one key point that I disagree with in Devin Stone's video. Devin also talks about the fact that the token contract is not worth anything, that the off-blockchain contract is key. He talks about whether or not that contract is enforceable, some of the things we're going to be talking about today and have talked about before. One key point I disagree with Devin Stone's analysis. Devin states that the token contract is not likely a contract that is enforceable in court, that it's not even a contract that there's no offer and acceptance and there are no contract terms in the token contract.
Now, one of the things that NFTs can do is that they can be attributed with some basic programming, so-called smart contracts. Now, and these smart contracts are basically contracts in the same sense that a microchip is a contract. It's not a legally binding document. It just has a bit of programming to do things when certain conditions are met. And these smart contracts seem to do well when they are based on internet native occurrences and simple transactions, the kind of thing like an escrow account where you don't release funds until certain conditions precedent are met. But these smart contracts, these tiny programs, are not real contracts. They don't bind the downstream purchasers. And in fact, as we've seen, they can break over time. There are no legal rights that are created as a result of the smart contracts themselves.
Now, I understand Devin's point, but I actually take a different view. The token contract does have basic contract terms. For instance, I own the token. I can transfer the token, the buyer of the token becomes the new owner of the token, and royalty rights. Those are baked into the token contract. So when you buy a token, there's no question you have access to all those contract terms. And in many instances, those contract terms are implied. Everyone knows that's what's happening. I'm buying the token, or I'm selling the token, and that there are going to be royalty rights baked in. You certainly have an obligation as a buyer to take a look at the token, which is certainly going to be available to you as part of that sale. Take a look at it and see what those contract terms are. So there's offer, there's acceptance, there are contract terms, there's consideration. I believe that the token contract does have enforceable rights, that it is a contract that could be enforced in court. Now, it might not be worth very much money because it's just a bunch of software code. It is an indication of ownership of some other asset, potentially, but the token contract, I believe, is the key to the future of non-fungible tokens and creating a model where rights are not only being passed in the token contract, that there's offer and acceptance in the token contract, but that the linked digital asset contract is also enforceable in a court of law. And we're going to talk about how to pull that off, how to change the dynamic of what's happening today into what I believe will become the model for non-fungible token sales in the future. But in order for that to happen, there has to be an enforceable token contract, and I believe that there is. The next thing we have to talk about is what is the linked digital asset contract. We talked about how that's going to contain the rights that you are securing as a buyer, potentially, in the linked digital asset, the image, the music, the video, or of any other digital asset that can be uploaded to a server. So the linked digital asset contract is going to contain those basic terms. But in order to have an enforceable contract, you have to have offer, you have to have acceptance, you have to have consideration. Consideration really isn't a problem. So let's take a look at offer and acceptance. So let's say I mint an NFT, I put it onto OpenSea, and I offer it for sale. And I've offered that token. The token contract is listed as part of the OpenSea offering. The actual token identification is there, displayed on the page for OpenSea. So I can see the token contract, I can see the token, and I can make a offer to buy that token from the person who originally receives it after minting. So the person who mints the token can sell it to the first buyer. The first buyer can sell it thereafter to a subsequent purchaser. Let's just focus on the first piece. I mint the token, the very first buyer, they come to OpenSea because that's the only way to get the token. They come to OpenSea and they make an offer. I accept the offer, or it's a buy now, and they secure that token. The first buyer secures that token. Okay, that token has got some contract terms in it. Let's just assume that there's an offer acceptance on the token terms. Who owns it? What are the transfer rights? Whether or not there are going to be any royalties, purchase price, etc., are going to be recorded on the blockchain. But what are the rights to the linked digital asset? Where do I find this linked digital asset contract? And you're going to find out that that's really the problem, the practical problem that exists right now with these marketplaces and with the way that NFT projects are going about launching their project. In most instances, there is no linked digital asset contract. There isn't even one drafted. So the linked digital asset, there's no contract terms. There's no contract terms as to what is being sold, what is being transferred, and what is being purchased. There's no ability to enforce rights from either the project owner to the first buyer, the buyer to the project owner, or any subsequent buyers in the chain of token contract sales down the line. In some instances, you will see as part of the listing in either the listing account owner's about information or on the specific NFT sale page in the details in the about information about that particular digital asset, you will see a link or a link to a website that could take you somewhere where maybe you will see a linked digital asset contract. Well, that's problematic if you're not telling the buyer that you can find the linked digital asset agreement here, and by buying the NFT, you're agreeing to those terms. If you simply have to guess that you have to go to the website and find the terms of service and see if there's anything in there, no court is going to enforce that linked digital asset contract, those terms of service that are on some website. No court's going to enforce those against a buyer. The reason why is you can't accept what you don't know exists, and it has to be conspicuous. Those terms have to be conspicuous. So at a minimum, you need to tell on your details page, on your about information, that there are additional terms that accompany this NFT sale, that those terms are found by clicking on this link, And then you have something like a browser wrap agreement. It's not the most enforceable agreement. It's not as enforceable as a click wrap agreement, but at least it's something. Now the next level up is to have an NFT sale where you're required to click I agree. That functionality doesn't exist right now on the platforms. If you have a closed platform that you own and control, you can bake a click wrap agreement into that. That's a huge advantage if you happen to be something like Top Shots, where only the sales can only occur between people within that platform, where you can force a click wrap agreement. But at a minimum, you need this off-site contract to be conspicuously identified. Now, the offer and acceptance in the first sale after minting is potentially a little bit easier problem to solve, because if you go through OpenSea and you do put the contract terms in the about information, you tell everyone that they have to click on the link and that link is part of the contract, that's good. But what about all subsequent purchasers? Because keep in mind, those subsequent purchasers might buy through OpenSea where they see that same about information, and so maybe there's offer and acceptance. I don't know how you would ever be able to enforce that unless you had a walled garden platform like Top Shots. But you have to figure out, how are the future buyers of the NFT, how are they going to receive rights, and how are you going to impose limitations on them? And you're going to see currently there really isn't a solution to that problem on OpenSea or Rarible. There is no way to have the initial linked digital asset contract terms be offered and then accepted by future purchasers, by buyers from the initial buyer. So did they have notice of the fact that there were linked digital asset contract terms? Maybe, maybe not. Did they agree to them? Maybe, maybe not. These are problematic issues if anyone should have to enforce rights in a court of law. Let's take a look at where you can find linked digital asset contracts. Let's take a look at a couple of different examples. Let's look at Bored Ape Yacht Club. So let's start backwards with Bored Ape Yacht Club. Here are what I believe they intended to be the linked digital asset terms for purchases, post-mint purchases of Bored Apes. And these are the same terms that were there on this web page at the time of minting. So the original buyer of the Bored Ape potentially seen these exact same terms if they had gone to the website to look to see what the linked digital asset license or assignment rights were. Let's back up though. Let's go to the OpenSea platform where these Bored Apes were minted. Let's take a look at whether or not any purchaser, post-minting purchaser of a Bored Ape, would have even known that these contract terms existed. And the answer is no. Not in any sort of reasonable sense. There was no notice that these contract terms existed that were publicized or made available by Bored Ape Yacht Club. Because if we look at the listing page, you'll see there's nothing here that says the linked digital asset, the image of the Bored Ape, is subject to these off-block contract terms. There's no link to those contract terms. In order to even know they existed, you would have to guess by doing your own research by clicking on this link here, which takes you to the website, but even there, it doesn't tell you there are any terms. You would have to know to scroll all the way to the bottom and to click on the terms of service, and then there, by sheer luck, you might find the contract terms that go with the linked digital asset. So that's not going to hold up in a court of law, and so it is very likely that the Bored Ape Yacht Club could not enforce any limitations on the initial buyers. So that's a problem. Let's take a look at the RTFK Nike NFTs. And if you see here, they've got Nikes. There's going to be all kinds of contract terms you're going to want around this, this particular NFT, because Nike's brand is associated with the shoe, which is being purchased, you know, as an NFT. So does Nike really want an avatar of Hitler running around in these Nike shoes, or someone who's involved in hate crimes or a mass murderer being able to use this shoe in the metaverse? No, but where are the terms that say they can't do that or that limit the use? Now that just leaves the question of how would they ever enforce aside. Let's get to that in a later video. We're just talking today about offer and acceptance of contract terms. All right, so here is an example of a linked digital asset contract where the project owner is telling people there are additional terms and are linking to them from the sale page. If we click on the link for the Nike offering, great. There it is. It's right in the description. We click on it. It takes you to the digital collection terms. Would be better if it was a click wrap, but look at, we've got terms. They've got an updated date. You can't update after the initial offer and acceptance, but let's put that aside. You've got your licensing terms. What exactly are you purchasing if you're the first purchaser anyway? Potentially additional purchasers to the extent they have actual notice. And then you can see all these different terms that they're including in the linked digital asset contract. Way more than in the token contract. This isn't about ownership of the token. This is about what your rights are in that digital Nike shoe. Transfer rights, transfer fees, upstream royalties. You've got compliance with marketing guidelines. You've got third-party infrastructure and services disclaimers. You've got indemnification, disclaimer of warranties, limitations of liability, and termination of license rights. Why might you lose your license rights? Now you might own the NFT, but you might lose your right to the shoe. And as I mentioned before, any breach of the agreement, of this linked digital asset agreement, should void the copyright license. That means even if you own the NFT and it's still linked to that digital asset, the owner of this project, Nike, can do a Digital Millennium Act takedown notice to have the linked digital asset removed. They can sue for breach of contract. If it's a registered copyright, they've got statutory damages against the owner of the NFT if they keep using the NFT. There's no clawback here. There's no way for them to pull back the NFT because the NFT is on the blockchain. But look at this. Without limiting the foregoing, right? You may not engage in violent, hateful, harassing behavior. This is a branded NFT play, meaning the brand has to control how the NFT is used by the user and has to have an ability to terminate the license if there's an inappropriate use of that token and associated linked digital asset. Wow, that's a lot, right? And I am a big proponent of blockchain and non-fungible tokens, so I'm not here to discourage anyone. I am here to solve problems. And in order to solve problems, we have to identify the problems. And the good news is these things are fixable. If attorneys had been involved in the beginning of the NFT craze, then we wouldn't be having these problems in these discussions today. So let's talk a little bit about possible solutions to the problems for projects who haven't launched yet and fixing the projects that have launched which may not have enforceable linked digital asset contracts. They may not have any enforceable terms between the buyer and the seller of the token. There are two possible solutions to this problem. There's more than two, but two obvious solutions to the problem of creating an enforceable linked digital asset agreement between the project, the mint, and the initial buyer. The first solution is to create a walled garden around your project where every NFT sale and purchase has to go through your platform, because then you could create a click wrap, you can force people to say, I agree, you can make the terms conspicuous. So Top Shop is a great example of a platform that is walled, where they can create and enforce contract terms, that they can create the opportunity for offer and acceptance notice of all material terms. So we're going to see more of these walled garden approaches. The reason that they don't happen as much right now is because everyone wants to go to OpenSea because that's where most of the buyers are. So OpenSea and Rarible and some of these other open platforms need to make some major upgrades in order to actually survive into the future, because the first big piece of litigation that comes down where it's established that none of the sales that go through OpenSea or Rarible are enforceable contracts, believe me, there is going to be anarchy, and hopefully they'll fix it before we get to that point. The second solution is to actually bake into the token contract not only a link to the digital asset, the image, the video, the audio file, but also the linked digital asset agreement. There is no technical barrier to providing a link to a permanent, unchangeable, immutable linked digital asset contract that goes with that token sale. Now, think about the elegance of this approach. So if everyone who buys that token down the line has actual or constructive notice of the linked digital asset contract as it's baked into the token, you've now got the potential for offer and acceptance. So how do we do that? So clearly the token which links to the digital asset, the image, when you go to a platform, you see the image and you see the token contract ID. And so you can see both of those items. What needs to happen on these platforms is not only does the image, the audio file, or the video get displayed, but the linked digital asset token contract gets displayed as well. So not only do you have it baked into the token and you have this kind of constructive notice that there are additional contract terms, but you have displayed in the platform the contract that's going to go with the initial sale, post-mint, and all subsequent purchases down the line. All right, now that solves potentially the problem of future NFT projects. How do we fix the projects that are already out there? How do we fix Bored Ape? How do we fix CryptoPunks? And that's a contract modification issue. So that's a little bit more complex, but again, great news. Great minds can fix this problem. Are you enjoying today's video? If it's informational and you're finding that the content is valuable, I have a favor to ask. Go ahead and hit the subscribe button below, like this video, and then that way you'll stay in touch with all the next latest videos that are coming down the pipe that are going to discuss various legal issues concerning blockchain, NFTs, and crypto. You're going to want to be part of the discussion. And speaking of discussion, if you have any questions, any legal questions or otherwise, go ahead and drop them in the comments. I will answer them all. All these problems can be solved. Let's solve them together. My name is Enrico. We'll see you next time.